Once that document is unsealed, what then? What happens if the names of the people that she targeted through those invasive subpoenas sent to all the social media companies, if they're not on that list that Tag provided, doesn't that mean she lied? And if she lied, isn't that very, very bad? This is it. This could be a huge mistake.
Blake Lively's legal battle with JustinBaldoni has taken a dramatic and potentially catastrophic turn that could fundamentally undermine her entire case. Recent developments reveal that Lively's legal team has issued subpoenas to content creators who appear to have absolutely no connection to Baldoni's alleged smear campaign. Among those targeted is a stay-at-home mother who operates a YouTube channel with a single subscriber and uses bedazzled kitchen utensils as microphones. This isn't merely an overreach. It represents a legal strategy so broad and potentially baseless that it threatens to expose Lively to significant liability while simultaneously destroying whatever credibility remained in her allegations. The stakes couldn't be higher, as the unsealing of crucial documents may soon reveal whether Lively's team fabricated connections that simply don't exist. The controversy stems from Lively's lawsuit against Baldoni, in which she alleges a coordinated smear campaign designed to damage her reputation.
Let's go over to Blake Lively here. I'm going to play a TikTok, Blake Lively's biggest mistake yet. We have here's his, I believe her name's Saran, and she's talking about these gigantic mistakes that Blake Lively is making in seeking to subpoena content creators that seemingly have no ties to JustinBaldoni. Was Blake Lively lying? Did she receive faulty information?
Central to her case is the claim that Baldoni's crisis management firm, Tag PR, orchestrated negative social media coverage through a network of paid influencers and content creators. However, Lively's legal strategy has expanded far beyond targeting alleged conspirators. Her team has issued sweeping subpoenas to social media platforms, demanding comprehensive data on content creators who discussed her case publicly. These subpoenas seek extensive personal information, including private communications, financial records, and detailed user data from platforms like YouTube, TikTok, and Twitter. The legal justification for these broad information requests hinges on Lively's assertion that she possesses evidence linking these creators to Baldoni's team. Critically, she claims this evidence exists within Tag PR's sealed client lists and communications, which have not yet been made public.
Is this idea where Blake's side said, we know all of this information exists on Tag's client list, but they have the information sealed, so we can't share it with anyone. And then Tag says, we're going to unseal it for you. So we've yet to see what that unsealed document looks like, but it was a game of chicken, a game we're assuming Blake Lively.
The most striking example of potential overreach involves a content creator known as Kenz, a stay-at-home mother who operates a modest YouTube channel. At the time she received her subpoena, Kenz had exactly one subscriber, reportedly her own mother. Her setup consists of bedazzled kitchen spatulas serving as makeshift microphones, hardly the sophisticated operation one would expect from a professional influence campaign. Kenz has since grown to over 2,000 subscribers, largely due to the publicity surrounding her subpoena. In her legal response, she characterizes Lively's demands as overbroad and invasive, arguing that the requests are irrelevant, disproportionate, and designed to be an intimidation tactic.
Now, most people watching this are going to go, we didn't trust a word she said in the first place, but this will be even more egregious as, it's sucked in a bunch of, folks that really are just, mommy sleuths. Here we have Kenz. Kenz is a stay-at-home mom, uses bedazzled spatulas as her microphone. She had one YouTube subscriber.
Her motion to quash the subpoena makes a compelling argument. The move-in at the time of receiving the subpoena notice from Google had one subscriber on YouTube. This proves the complete disproportion of Miss Lively's fishing expedition. She further contends that the subpoena reflects a speculative fishing expedition rather than a targeted search for evidence. From a legal perspective, Lively's approach raises several critical concerns. Federal courts have consistently held that discovery requests must be proportional to the case's significance and must seek information reasonably calculated to lead to admissible evidence.
Subpoena-gate. One YouTube subscriber. Who's that lucky person? Her mother? Either way, Kenz is fantastic. I got this slide from her YouTube channel. I'm gonna promote her in a second here. She has since grown from one subscriber to 2,000. So
subpoenaing individuals with minimal online presence and no apparent connection to the defendant suggests a fundamental misunderstanding of these requirements. The timing of these subpoenas creates additional strategic problems. By issuing broad demands before establishing factual foundations, Lively's team has potentially violated Federal Rule of Civil Procedure 26, which requires discovery to be proportional and targeted. Courts increasingly scrutinize phishing expeditions, particularly when they impact third parties who aren't direct parties to the litigation. More problematically, Lively's justification relies heavily on sealed documents that allegedly contain evidence of these creators' involvement.
In her response to the subpoena, she says it's overbroad and invasive. It is fair to say the request is irrelevant, disproportionate, and designed to be an intimidation tactic. The mouvant, at the time of receiving the subpoena notice from Google, had 1 subscriber on YouTube. This proves the complete disproportion of Miss Lively's phishing expedition. It suggests that plaintiff is not pursuing legitimate evidence, but rather attempting to identify and intimidate critics. The subpoena issued by plaintiff reflects a speculative phishing expedition rather than a targeted search for evidence. The lack of any factual basis for such invasive requests strongly suggests that the so-called smear campaign alleged by plaintiff has no foundation in...
This creates a logical paradox. She claims to know these individuals are connected to Baldoni's campaign, but she cannot produce the evidence supporting these claims because it remains sealed. This approach resembles asking a court to trust unverified assertions rather than demonstrated facts. The legal doctrine of good faith requires attorneys to have reasonable factual or good faith legal bases for their discovery requests. If the unsealed documents fail to demonstrate connections between the subpoenaed creators and Baldoni's team, Lively could face sanctions for abuse of the discovery process. The controversy has created what observers describe as a game of chicken between Lively's team and Tag PR. Lively argues that crucial evidence supporting her claims exists within Tag's sealed client communications and strategic documents.
Person on social media, I'm not going to say their name. There's one person on social media who seemingly is paid off by Blake Lively, could even be artificial intelligence. I have no idea who this person is.
She contends that these materials will vindicate her broad subpoena strategy by revealing extensive networks of paid influencers and coordinated messaging campaigns. Tag PR has agreed to unseal these documents, effectively calling Lively's bluff. This decision suggests confidence that the materials will not support Lively's characterizations. If the unsealed documents fail to demonstrate connections between the subpoena creators and any coordinated campaign, Lively faces several devastating consequences. First, her credibility would suffer irreparable damage, as her legal team would appear to have made specific factual claims without adequate foundation. Second, she could face Rule 11 sanctions for making frivolous legal arguments or discovery abuse.
Here's what Kenz has to say regarding her response to the subpoena.
In my motion to quash, I stated, the lack of any factual basis for such invasive requests strongly suggests that this so-called smear campaign, alleged by plaintiff, has no foundation in reality. That was the nicest way I could put it. Another Easter egg, the New York Times, where criticism and mistakes are a price to pay for democracy.
Third, the individuals she subpoenaed could pursue their own legal actions for harassment or abusive process. The unsealing represents a critical inflection point in the litigation. Rather than strengthening Lively's position, it may expose the fundamental weakness of her entire legal strategy. This case highlights troubling trends in celebrity litigation and the weaponization of legal processes against online critics. The ability to issue subpoenas to social media platforms creates powerful tools for identifying and intimidating critics, regardless of whether those critics have any actual connection to alleged wrongdoing. The economic dynamics compound these concerns. Most content creators lack resources to mount sophisticated legal defenses against celebrity subpoenas. The mere threat of extensive litigation costs can silence legitimate criticism, creating a chilling effect on free speech and public discourse. Protection. If courts sanction Lively's broad subpoena strategy, it could discourage similar phishing expeditions in future cases. Conversely, if her approach succeeds despite its apparent overreach, it may encourage more aggressive targeting of online critics. The outcome will also influence how social media platforms respond to third-party subpoenas. Currently, these platforms often comply with legally sufficient subpoenas without extensively challenging their scope or foundation. More aggressive judicial oversight could encourage platforms to more rigorously contest overbroad requests. For content creators, this case represents both a cautionary tale and a potential victory for free speech principles. Ken's articulate legal response demonstrates that even small creators can effectively challenge celebrity legal intimidation when they receive appropriate support and representation. The broader entertainment industry is watching closely, as the precedent could influence how celebrities and their legal teams approach reputation management in the digital age. The traditional model of controlling narrative through media relationships has proven inadequate in the era of independent content creators and social media commentary. Moving forward, legal practitioners may need to develop more sophisticated approaches to distinguishing between legitimate reputation protection and abusive litigation tactics. The challenge lies in preserving celebrities' right to defend against actual defamation while preventing the legal system from becoming a tool for silencing legitimate criticism. The unsealing of Tag PR's documents will likely determine not only the immediate outcome of this dispute, but also the longer-term trajectory of celebrity litigation strategies in the digital age. The stakes extend far beyond this individual case, potentially reshaping the balance between reputation protection and free speech in online environments.